Hello class, this is Cheryl Conley and I am going to be delivering your PowerPoint today on legal ethical issues in nursing. Some of this material today you have had in prior courses, and so this is a refresher course and material. Basically, you'll learn some new stuff, but it will build on the old material as you're getting ready to graduate, just to bring some of these concepts back up to the forefront. So I'm going to start with the sources of law. As a reminder, our government is divided into three branches. Each branch obviously have particular powers. Our federal government is comprised of the executive branch, the legislative branch, and the judicial branch. On the board, you see statutory law. That basically falls under the legislative branch of government. Statutory laws govern nursing practice in all states and territories of the United States. The Nurse Practice Act falls obviously underneath statutory law. The administrative law, also known as executive law, is where the Board of Nursing falls under. The Board of Nursing is appointed by our governor. The board primarily acts on disciplinary issues and also helps to approve nursing education programs. Judicial law, this type of law is created by the judicial branch, and it involves courts' decisions to guide practice. So it involves the Supreme Court and lower courts. Again, the Nurse Practice Act provides the laws that control practice of nursing in each state. And just so that I'm absolutely clear, every single one of our states in the United States has their own Nurse Practice Act. And so it is not just, for example, Florida has their own Nurse Practice Act, California has their own Nurse Practice Act, Michigan has their own Nurse Practice Act. And what that Nurse Practice Act does is it provides the laws that help control our practice in each of our states. Know that our practice and our scope of practice can be different, and quite often is different, based on the state that a nurse lives in. For example, nurse practitioners fall under this, in fact, all registered nurses, but nurse practitioners in particular, depending on the state that they live in, their Nurse Practice Act may say that they have the authority to be able to write Class 3 narcotics prescriptions. Whereas in the state of Florida, under our Nurse Practice Act, it says that they do not have this legal right. So again, the Nurse Practice Act provides the laws that control the practice in each state. Under our Nurse Practice Act, it basically says that only licensed professionals can practice nursing. And so it's also important to know that unless you are a nurse, you cannot call yourself a nurse legally. And I know that sometimes when you go into, doctor's offices or something of that nature, the person who is caring for you or who might be taking your history, your vital signs, that sort of thing, they might identify themselves as the nurse. But really, to be legally sound, again, only licensed professionals can practice nursing and call themselves a nurse. If they are truly not licensed, they should not be using the term nurse. Again, all states have mandatory Nurse Practice Acts. The question on the board is, under what category of law does the Nurse Practice Act fall under? And I want to make sure that you are absolutely clear that it falls under the statutory portion of the law. The statutory law governs nursing practice in all states and territories, and so that is the branch of law in which it falls under. So let's talk about the types of law. We're going to talk about civil versus criminal law. Under civil law, the plaintiff is usually seeking monetary damages. Also under civil law, there is something called torts, and torts can fall under two categories. They can either be intentional torts or unintentional torts. When a person sues another person for or under civil law and they charge them with either an intentional or unintentional tort, know that it is an act involving injury or damage to another person. And if they are suing them in a civil court, basically the plaintiff is seeking monetary damages because of the unintentional or intentional tort. Some examples of tort law include malpractice. Know that a person cannot be charged with malpractice unless they are deemed to be a professional. So nurses, respiratory therapists, doctors, all of those people are considered to be professional people. They hold a degree and they are considered professional. So those people, like your grocery store workers, custodians, housekeeping, none of those people can be charged with malpractice because, again, this is the portion of the law that is reserved, so to speak, for professionals only. It means that their standard of care that they are required to give was not met in some way, and so they are being sued for malpractice. Negligence is a breach of duty. Basically, the definition is on the board. It is a failure of an individual to provide care that a reasonable person would ordinarily use in a similar circumstance. For example, if a nurse comes upon a car accident, I would be expected as the registered nurse to act in a certain way. If I fail to act as a reasonable person would in my same circumstance, I can be charged with negligence. So, for example, if I come upon that car accident and I suspect that the person has some type of neck or head injury, a reasonable and prudent nurse in that same situation would take care in removing that person from the car if they had to. They would stabilize the patient's neck to prevent them from further damage. But if I came upon that same accident and I pulled the person from the car without any regard to neck injury, I could be sued with negligence only because I was not acting as a reasonable, prudent nurse in my same situation would act. Okay, so that's what negligence is, a breach of duty. Malpractice, is a type of negligence, and then we're going to talk about liability versus accountability. When you hear the term accountability, basically you need to associate that with responsibility. It is an obligation to give an account of what happened. Nurses, registered nurses in particular, are almost always held accountable for all the care that they give and any person that they supervise. And so if you have an LPN on your team, you are accountable for that LPN's care that they give. However, liability is something separate. Liability is the legal responsibility for one's acts or omissions. Just because we are accountable to something does not make us, as registered nurses, liable for everything. For example, if you are say that you are doing some team nursing and you are the registered nurse and you have an LPN who is also working on your team, your LPN, their scope of practice includes medication pass. And so if that LPN who's working on your team causes or has a medication error, say that they gave the wrong dose of Coumadin. Say they were supposed to give 5 milligrams of Coumadin PO to a patient, and they went in and they made a med error, and instead of giving 1 tablet, they gave 2 tablets, and they gave 10 milligrams of Coumadin. As the registered nurse, you would be accountable or responsible to give an account of what happened because that LPN was working on a team with you. You would not, as the registered nurse, be held legally liable because the LPN has her own scope of practice, and she has been checked off on PO medication pass. So the liability falls on the LPN. So I want to make sure that you're clear that there is a difference between accountability and liability. Now, if the registered nurse who was also working on that team delegated improperly and told the LPN, go and hang and spike my blood for me, that would be improper delegation. And because of that, the registered nurse would be held accountable. She would have to give an account of what happened, but they would also be legally responsible for improper delegation. Okay, the LPN would also be liable in the fact that they practice out of their scope of practice as well. So, on the board, going down to the next third sentence on the board, proof of liability. When we say that somebody is legally responsible, there falls a burden to prove liability. And so liability depends on a few different things. One of the first things that liability falls on is something called duty. We have to prove that there was a duty in that particular situation. The outcomes of some negligent cases depend on whether the defendant owed a duty to the plaintiff. Okay, so it will depend on whether some negligent cases, whether or not the patient or the nurse had a duty to the patient. Such a duty arises when the law recognizes a relationship between the defendant and the plaintiff. And due to this relationship, the defendant is obligated to act in a certain manner towards the plaintiff. So, when patients are assigned to a nurse, that is where duty comes into play. If the patient is actually assigned to the nurse on the floor, then that nurse has a duty to that particular patient. Breach of duty is the second proof of liability that comes into play. And a breach of duty is, here's the definition. It's basically when a defendant is liable for negligence. This can happen when the defendant breaches the duty that the defendant owes to the plaintiff. A defendant breaches such a duty by failing to exercise reasonable care in fulfilling the duty. And so, for example, when my patients are assigned to the nurse, there is obviously duty that the nurse has to provide some kind of care to the patient. A breach of duty would be things like the nurse is responsible for passing medications to the patient. The nurse is responsible for doing sterile dressing changes to change out their IV fluids, that sort of thing. If the nurse fails to do the duties that are assigned to her, then that can be considered a breach of duty. Injury is the third portion in legal responsibility, and what injury is having to establish if the defendant or the patient actually suffered injury. And so, for example, if the nurse was responsible for changing out an IV catheter in the patient's arm, if she failed to do that, but there was no consequences to it, say that, they just forgot, it's the third day, they're supposed to change out that IV catheter, and the nurse just forgot, she didn't have time to do it. If it causes no harm or injury to the patient whatsoever, they can't sue the patient, or they'll have a hard time suing that nurse for malpractice. However, if the IV was supposed to be changed and the nurse didn't do it for whatever reason and the patient suffers injury, say that they end up with a rip-roaring infection and sepsis because of it, and the patient is actually injured, the nurse can be sued for malpractice because of actual injury to the patient. Causation also goes along with it. This is the fourth component of proving negligence or liability. when they are looking at whether or not they're looking at causation. So they're looking at, did the duty or the breach of duty actually cause the injury? And so they have to actually prove that by leaving in the IV, the patient ended up with sepsis because of that particular nature. They have to make sure that that sepsis truly was linked to the IV catheter being left in place, not because of any other problems going on with the patient. So again, proof of liability depends on duty, a breach of duty, injury, and causation. Remember that the RN can be held liable if he or she did not act within their scope of practice, or if they improperly delegate, because the law says that as the nurse, you have a scope of practice that you have to follow. Within that scope of practice, your responsibilities as the RN is to delegate. And so if you do not act within your scope of practice, or you improperly delegate to an LPN or a CNA, then you can be held liable. The RN is almost always accountable for all outcomes of the patient. Let's move on to civil versus criminal law. Under civil law, the plaintiff is usually seeking monetary damages. And so when they go to court, that is the number one thing that they are seeking from the defendant. They want them to actually pay them some type of monetary stipend for their injury or for their claim. Under civil law, there is something called torts, and a tort can be subdivided into two additional categories. So we have torts that are either intentional or unintentional. And so a tort is an act involving injury or damage to another person. And an example of an intentional tort would be where a person damages another person or injures another person on purpose. The person is usually, if they are found guilty under civil law of a tort, they are more heavily punished, so to speak, if the tort or the act involving injury is malicious in nature. An example of an unintentional tort where there is damage or injury to another person would be a car accident. When we get in our vehicles every day, we do not intentionally go out to injure or damage another person. So that would be an example of an unintentional tort. It might happen as a result of the car accident, but we have no act to actually go out and intentionally do it. So that would be an example of intentional versus unintentional tort. Some examples of tort law are listed on the board. Malpractice and negligence both fall under tort law. With malpractice, that is the portion of civil law that is reserved for professionals only. And under malpractice, the standards of care are not met. And because it only applies to professionals, people like doctors, nurses, respiratory therapists, social workers, things like that, they all fall under the umbrella, so to speak, of professionals and can be sued for malpractice if the standards of care are not met within our field. And so, for example, with malpractice, if it's the nurse's duty to change out IV fluids every 24 hours, TPN in particular, and that's our standard of care for that particular practice. If we do not do that and the patient ends up ill or sick or suffers any kind of damage because of that, the nurse can be sued for malpractice because she did not or he did not follow the standards of care. Because it refers only to professionals only, people like your gas station attendants, your Walmart greeter, dietary, housekeeping, they do not fall under the umbrella of professionals. And I'm not saying that they aren't important. I'm just saying that that portion of the law, they cannot be sued for malpractice, for example. Negligence, on the other hand, is a breach of duty, and it's failure of an individual to provide care that a reasonable person would ordinarily use in a similar circumstance. And with negligence, this is failure again of an individual to provide care that a reasonable person would in a similar circumstance. And with the example that I just gave you with the nurse not changing out the IV fluids, because she is or he has been deemed to be a professional, they can be sued for malpractice for not following the standards of care. So they meet the tenets just by being professional. They can be sued for negligence as well because the nurse did not provide care that a reasonable person would ordinarily use in a similar circumstance. So another example that I'd like to give you about this is, let's just say a nurse comes upon a car accident. And if the person within that car hits their head on the windshield, say that they were an unrestrained driver, and the nurse is first on scene, she opens the door and she sees the person in the car. If they are contorted in any way and the nurse suspects that maybe they have a neck or cervical injury, a normal, reasonable person having that nursing knowledge would come up and they would try to not move the patient or the person, or they would try and stabilize the neck before they actually move the person. And so if another person were to come upon scene with that same knowledge and they just yanked the person out of the car, they could be sued for negligence because they wouldn't have acted like a reasonable person would in that same similar circumstance. And so, in other words, whenever a nurse is sued for malpractice or negligence, they are held to the standards of or compared against another nurse. And what would they do in that? And that's the question, what would they do in that similar circumstance? Malfeasance, misfeasance, and nonfeasance. With nonfeasance, these are basically just definitions that you'll have to memorize. And so with nonfeasance, basically that is to ignore or to take no indicated action. Negligence falls under nonfeasance. If the nurse ignores spilled water on the floor and the patient falls, that could be deemed as nonfeasance. They would just totally ignore the simple fact that there was a hazard, so to speak, on the floor, and they don't take the required actions to keep the patient safe. And so that would be nonfeasance. Misfeasance is to take inappropriate action or give intentionally incorrect advice. And so the example that I have up on the board is if a patient has been ordered a K-pad, which is basically a heating pad, and it accidentally burns the patient, that is unintentional. We don't ever go in intending to burn a patient with a heating pad or a K-pad. So that would be considered misfeasance. If when we discharge a patient and we tell them, oh, you don't have to seek medical attention after what becomes an infected wound, that is that would be intentionally incorrect advice. And then, what would be hard to prove is that it was intentional, because I don't know anybody that would really deliberately give incorrect advice. So that's where the play comes in with misfeasance, is that it has to be proven to be intentionally incorrect advice. So inappropriate action or intentionally incorrect advice is misfeasance. Malfeasance, on the other hand, is hostile, aggressive action taken to injure the client's interest. So if the nurse is found stealing supplies and then charging those items to a patient's account, that would be malfeasance. Generally, a person will not be held liable unless he or she had a pre-existing relationship with the injured person. And so that is where It comes into play with, your patient assignments and that sort of thing, making sure that there truly was a pre-existing relationship between the nurse and the injured person. So here's a little bit more tort law examples. Assault and battery falls under tort law, and again, as a reminder, assault is the intentional and unlawful offer to touch a person in an offensive, insulting, or physically intimidating manner. And all we have to do is say that we are going to actually touch the patient, okay, or threaten to touch the patient, and that can be deemed as assault. Battery, on the other hand, is the actual touching of the other person without the person's consent. And so that you often hear assault and battery together. The person says to the patient, if you don't sit down, I'm going to tie you down. And then if they go and get restraints as a means of, when we could use other means, for example, as a first resort as opposed to a last resort, the nurse could be sued for assault and battery, one for threatening the patient in an intimidating manner, and battery would be for actually tying the person down. And oftentimes, with restraints, we don't get the patient's consent. I don't know any patient that says, oh yes, go ahead and tie me down. But the assault and battery, just to prove a point, you understand where I'm going with that. Assault being intentionally in saying it in an intimidating, offensive manner to the patient, and then battery is when we actually put our hands on the patient and touch them. False imprisonment also can include restraints or seclusion. Interestingly enough, one of the stories that hopefully will help you remember false imprisonment, if a patient is discharged home and the nurse doesn't feel in their own, in their own right mind that the patient should go home, if the nurse, for example, and I know no nurse would do this, but if they took the patient's clothes and didn't give the patient their clothes or took their car keys so that they couldn't drive home, that would be a form of false imprisonment. Invasion of privacy basically is the intrusion into one's personal life without just cause. And so I think everyone knows, an example of invasion of privacy. That's where our HIPAA laws come into effect with the invasion of privacy. Defamation and slander, you might hear. Defamation is the communication of false statements that harms the patient's reputation on an individual. It can be individual or a business that a person could do this to. And so when we write things and it's printed communication, they can be sued for defamation of character. Slander, on the other hand, which is not on the board, is spoken words. It could be sounds, sign language, gestures, things like that are basically offensive to the person. And then when those types of spoken words harm the person's reputation, they can be sued for slander. Fraud, on the other hand, is wrongful or criminal deception intended to result in financial or personal gain. It usually will involve trickery or cheating and or dishonest advantage or false representation. So moving on to criminal. Basically, criminal acts or offenses are usually against the welfare or safety of the public. And so with your civil cases, that usually involves individual to an individual. But under your criminal acts of law, these are offenses against the welfare or safety of the general public. And so I know that there's been a lot in the news about, bombings and things like that, the Boston Marathon bombings and things like that. Those individuals are charged on a criminal basis because they performed an act that was an offense against the safety of the public. And so in your criminal cases, the state is usually the prosecutor. And instead of just monetary damages, the prosecutor in this, under criminal acts of law, they're seeking punishment. And when I say punishment, they are actually seeking prison time for the person. So the question on the board is, what is the difference between jail versus prison time? And so with jail time, that is 365 days or less time. When we say a person has been sent to prison, it's 365 days plus 1 day. And so any time basically to just make it clean cut and even, jail time is less than a year, where prison time would be any time over a year. Question on the board is, in Florida, is it a requirement of law that a nurse must stop and render assistance or care at the scene of an accident? Assume that EMS has not arrived at the scene yet. And so in Florida, do we have to stop and render care? Surprisingly, I know that there are probably most of us who would think, well, if you are a nurse, you have a duty to actually stop and render care. But in the state of Florida, it does not, we don't have to stop and render care at the scene of an accident. Many times, what I hear is, I don't want to stop at the scene of an accident because I don't want to be sued. And so understand that we also have things in place to help protect us against that sort of thing. It is understandable because we do live in a very sue-happy society. But I'm bringing this up just so that you know, like if you pass a scene of an accident, you don't have to stop and render assistance. But personally speaking, I'm not sure how you can actually drive by and not render assistance if you see that the person is hurt. But those pros and cons you have to be able to outweigh. Standards of practice. The Nurse Practice Act of individual states defines the boundaries of nursing practice within each state. This is just a recap of some of the things that we have already talked about. So knowing that the Nurse Practice Act defines the boundaries of nursing practice within each state, also know that we have institutions, like your hospitals, for example, that develop internal standards of practice. And so just because our Nurse Practice Act says, for example, that nurses can push IV medications, understand that institutions develop their own internal standards, and most of them are in line with the Nurse Practice Act. But if they decide, for example, the Nurse Practice Act being, let's just use LPNs for example, if they give them a scope of practice, because the Nurse Practice Act with LPNs is very generalized, institutions like hospitals can put their own internal standards on what they will and will not allow an LPN to do within their facility. So know that those are outlined in specific institutions in their policy and procedures manuals, and a lot of those are based on evidence-based practice. And so you need to be familiar not only with the Nurse Practice Act, but when you go and work somewhere, it is important that you know the institution's internal standards of practice so that you can help protect yourself against any kind of lawsuits in our field. I'm not going to read this to you. This is the Patient's Bill of Rights. Basically, it was replaced by the Patient Care Partnership. On the board there are where the documents can be found, but you will see this, hung all over the hospital in our patients' rooms. You just need to, I would encourage you to read it and familiarize yourself with the Patient's Bill of Rights so that, when the patient comes in, they are entitled to certain things as a patient. And so you need to be aware, for example, protection of the patient's privacy. And we always need to be in line with the Patient's Bill of Rights. I bring this up. This is the Florida Good Samaritan law. I talked about earlier how some nurses may be a little bit hesitant resident to stop at the scene of an accident, but know that Florida does have a Good Samaritan law, and I am going to read this to you. Basically, any person who in good faith renders emergency care or treatment without objection of the injured victim shall not be held liable for any civil damages as a result of such care or treatment, or as a result of any act or failure to act in providing or arranging further medical treatment. And then this is where the big part comes in, where the person acts as an ordinarily reasonable, prudent person would have acted under the same or similar circumstances. And so we do have the Florida Good Samaritan law. As long as the person isn't objecting to being helped, we are protected from any type of civil damages as a result of the care that we give that patient, so long as we act as a reasonable and prudent person would act in that same or similar circumstance. And that's where the sticky part comes in. Well, what happens if you come upon the accident? You're not really sure, and so you will be held against the same standards of another person. And if you say that you're a nurse, and they know that you're a nurse, you're going to be held to the standards of a nurse. A bystander who has no type of health care background, they're not going to be held to the standards of a nurse, because they would be held against the reasonable actions of a similar person in a similar circumstance. Professional liability insurance. Many students ask, do I need to carry my own professional liability insurance? And a view that I would like for you guys to consider is that by having your own professional liability insurance, it helps protect you. Understand that having your own legal counsel provides you with a voice, because your interest in a lawsuit may not be the same interest as your employer in a lawsuit. So let me go back and make sure that you guys understand this. If a nurse is sued, if they are named in a lawsuit along with their employer, of course the hospitals have their own legal counsel. Understand that the legal counsel's first obligation is to protect the hospital itself. Okay, I'm just using hospital. It could be any agency, but their legal obligation would be to protect the hospital first. The nurse comes second if they come under that same umbrella at all. And so it is highly recommended that if you're going to be providing care to a patient, you may want to consider getting your own professional liability insurance. What I ask you to do is not advertise at all that you have professional liability insurance to any patient whatsoever. If you are asked, just defer the question. Do not answer it. Because unfortunately, we do live in a society where people are very sue happy. If they know that you have $1 million professional liability insurance policy, they may find reasons to actually sue you, and you don't want to put that out there. Unfortunately, hopefully we don't come around, in contact with too many of those people, but you just never know. So it is always recommended that if you work, to carry your own professional liability insurance, but again, just don't advertise that you have it. And again, just remember that we live in a very sue-happy society. That ends my PowerPoint on legal ethical issues in nursing. Again, you can contact me, at just send me any emails, any questions if you have any questions or anything that I can clarify for you. Thanks and have a great day.